with no further delay, thanks a lot, everybody, for joining us. Stefan, I hadn't talked to you. Good to see you. Good to see you.
Good to see you too. Thanks.
It's not in person as we've been in Japan, but it's gonna happen.
You remember that evening? That was wonderful. Thank you.
It's my pleasure. So Ricardo Medina is one of the top Brazilian construction attorneys here, and I would like to give him the floor to moderate this panel. Ricardo, the floor is yours.
Hello, everyone. Let me just hold on for a quick second so our organization here can see if José Emilio's camera can be turned on.
What I'm gonna do, you can start, Ricardo.
Okay, thank you.
I'll try, I'll go out and come back again and see what happens. Okay?
Okay.
You can move on, don't wait for me.
But don't you think you can just turn on your camera? I think there's an automatic way to do it here.
Not me, not on my side.
No? All right. So, okay, let's go on.
Okay, I'll go out and come back.
All right. Well, you know, I could only start by giving thanks to my dear IBDiC and ICLA colleagues and friends, and I do that in the name of Leonardo Toledo, our president, and the board of directors, for the privilege they granted me of being here today in the company of such tremendous professionals. It's a great honor to participate in such a well-organized event, really. I have been kind of way of the organization. Probably that's the reason why this is going so well. So great job, you guys. You know, IBDiC is what it is now, and it will keep growing because of you, that's for sure. And of course, you know, I could never forget, because of the legendary entities that are Jorge Jobim and Fernando Marcondes. You know, they both received the IBDiC award, and most certainly they deserved it, as they played stoic contribution not only to the institution but to the development of construction law in Brazil. Now, although I don't think our panelists would really need introduction, as they are so well known among us learners, I better follow the protocol, as Leonardo's standing right by me, and he would get mad, and it's better, you know, I get out of trouble right now. So let's do it. So just to enlighten us with their thoughts on the subject of this panel, that is coronavirus pandemic, the perspective of arbitrators and judges, we count on Professor Doug Jones. Professor Doug Jones is a leading independent international commercial and investor state arbitrator with over 40 years prior experience as an international transactional and dispute project lawyer. Doug's an arbitrator member at Arbitration Place in Toronto, a door tenant at Atkin Chambers, London, and has an office in Sydney. Doug is also an international judge of the Singapore International Commercial Court. He's been involved in over 130 arbitrations, which include construction, infrastructure, energy, commodities, intellectual property, joint venture, and investor state disputes spanning over 30 jurisdictions around the world. We also count on Professor Stefan Luppertz. Professor Stefan Luppertz, he is a former judge of the German Supreme Court and known as one of the leading legal authorities on construction law in Germany. During his tenure as a judge of the German Supreme Court, Professor Luppertz was assigned to the 7th Civil Division, being responsible for hearing construction, contract and architectural law disputes. In 2012, Professor Lupitz resigned as a judge of the German Supreme Court and commenced his own practice purely focused on construction law, in particular dispute avoidance and dispute resolution as arbitrator, adjudicator, and legal expert. Professor Lupert is particularly active and highly respected in academia. Professor Lupert works on numerous construction law-related boards. We also have the honor to count on Professor Janet Walker. Professor Janet Walker is an independent arbitrator with chambers at Arbitration Place, Toronto, Inner Arb Arbitrators, London, and Sydney Arbitration Chambers, Australia. Janet served as sole arbitrator, co-arbitrator, and chair in ICC, ICDR, DIAC, and many other chambers, and in ad hoc arbitrations in a variety of seats. Her matters range from construction, M&A, shareholder, intellectual property, pharma, and environmental law. Janet is professor of law, past associated dean at Osgoode Hall Law School, a member of the Ontario Bar, and licensed legal consultant of the New York State Bar. Now, this guy I'm about to introduce is a particular case. When I asked him to send me his resume, he wrote, "Attorney in São Paulo and no more." And this is funny because we all know his resume wouldn't fit in a book, the size of Moby Dick's. So here it goes. In addition to being a former vice president of the ICC, International Court of Arbitration, and current member of the London Court of International Arbitration, José Emílio Nunes Pinto is, as he says, an attorney in São Paulo. And on a personal note, an inspiration for all of us lawyers and arbitrators. Well, to go on, in view of our theme here, let's try to, the idea is to mix and match procedural and substantive questions. All speakers here on our panel, please feel free to weigh in anytime.
Thank you.
Doug and Janet, this question goes for you. The pandemic put the world upside down, and the arbitral procedures are undergoing unprecedented influence of these changes. And considering the construction arbitrations are so unique, what kind of arrangements have you been implementing to make sure the procedure work in terms of hearings, cross-examination, and hot tubbing, for example?
Well, that's potentially a broad field, Ricardo. We've had a long discussion this morning already about force majeure, but I had an interesting issue with force majeure in a construction arbitration involving a state party who said that because of COVID-19, it was prevented by force majeure from providing to the ICC the funds deposit available to fund the arbitration.
That's a good one.
Of course, arbitrations can't proceed, as you know, without some money. So this raised some serious issues, and the force majeure event arising from COVID-19 was said to be the constraints imposed in that state on the transfer of funds out of the country. Eventually, without the need for a ruling on force majeure as such, the money arrived safely in Paris, thank goodness, and the hearing will be proceeding virtually rather than in Paris as it was planned a little later this year. But that exemplifies the way in which that concept of force majeure being discussed earlier today has achieved a very broad usage as excuses for difficulties which emerge from the virus. But it's certainly the case that the challenges which those of us involved in arbitration, and I'm sure also in mediation, have faced, represented by the problems of social distancing and travel that has befallen all of us. And in terms of the process of arbitration, everyone has been on a very steep learning curve to do things which they had previously not done before. Telephone conferences were the usual way of communicating between parties on simple procedural issues, and occasionally one used to have witnesses who couldn't appear in person at an in-person hearing, appearing by video. Now, of course, hearings have had to proceed with counsel locked down with young children in their homes, with internet connections in what one would regard as very sophisticated societies such as the UK, severely degraded by the fact that there's apparently no adequate internet in the English countryside, and a range of other challenges that we're faced. But despite that, my experience, my personal experience, has been that things have moved forward with a fair amount of ease. It's a different environment, of course, and the way in which people react virtually is necessarily different. But a new normal is emerging, which I suspect will survive. Beyond that, construction arbitration, of course, as you say, has particular characteristics that distinguish it from many other forms of dispute. M&A disputes and other things are certainly complex, but they do not involve the masses of documentation and evidence that a construction arbitration does. So marshalling the capacity to deal with that has been and remains a continuing challenge. But I suspect that it's true that those of us who practice construction law and love doing so have, in our experiences, found ways of dealing with complexities which perhaps colleagues in other areas of dispute resolution have not had the opportunity to do. So construction lawyers, construction arbitrators have brought to the table, I think, the innovation which our clients are noted for, and we're managing quite well. But there's a fair bit of detail. The devil is in the detail of making these things work. And I'm sure Janet's got some views about the detail.
And thank you very much, Doug. Ricardo, Leonardo, thank you so much for including me in this wonderful event. With colleagues at ICLA, thank you also to IBDiC. You are yourself a force to be reckoned with, if not a force majeure. So this is a wonderful event in which I'm sure that in 2002 will be remembered fondly by all of us when we are together in Sao Paulo. So looking forward to that. And as Doug said, there was a brief pause at the beginning, arriving back on February 29th to a very chilly Toronto, never imagining for a moment that I would soon surpass the time when I had been in one place at one time for such a long time, so quickly. Everyone seemed to sort of brace for impact in Toronto. And then a few weeks later, of course, everything shut down and there was a collective intake of breath. What should we do now? That came for me at a time when I had a hearing due just 3 weeks later. And of course, what should we do? There were at that time no protocols in existence needing to anticipate how we should proceed. And immediately counsel, of course, said what you'd expect. We need a postponement. And the first thought was, well, surely you must be very nearly ready to go to a hearing. Let's find a way to go online and that will be straightforward. But immediately it was quite clear that the preparation that counsel needed still to do was going to be very difficult for them. Suddenly, in their own homes with all of their children, not at school, and no care arrangements for them. So those sorts of things have been playing out in many different ways throughout arbitral hearings. But as Doug has said, things seem to right themselves in the sense of disputes very quickly. Having said that, with construction disputes, as with others, with the extensions of time, with the court times and other dispute resolution times being extended, it seemed to me there was a slight lag. And suddenly now, in the last month, everything has been coming on stream in terms of people proceeding in terms of dispute resolution. So we're very much seeing a ramp up, and I'm sure that there will be a large number of disputes, notwithstanding Aisha's very strong and very welcome recommendation that we work things out and move forward. There will be a great deal more that we need to deal with. Having said that, I think dispute resolution specialists in construction law and elsewhere have been very ingenious in adapting very quickly to the new normal. Some very basic things are easy to sort of state to put in place. Have a hearing facilitator, use one of the major centers to organize your hearing. Yes, we can all get very easily our own Zoom accounts and flip the switch and hope that it will all be well. But those professionals are way ahead of so many of us in ensuring, for example, that every participant is able to see and speak and be heard and see clearly what's going on. They will do all of the testing of the tech, which actually comes down to each and every one of us. Is not limited to our law firms, but comes down to each and every one of us in our own homes. They will test that tech, go online, see the main protocols for hearings that are out there, and there are now many available that will deal with the many details for virtual proceedings, and follow those very carefully. But some of it also comes down to each and every one of us for a very small experience, very small investment in improved technology, a good camera, a good internet connection, a hard wire plugged into the modem or plugged into the wall, just as we used to do in the old days. Some of these very simple processes ensure that we actually have reliable and good access to the hearing. Also making sure that we have a good decent sized screen so we can see our participants presented well, being able to focus on ourselves and speak to the camera. All of these things I think are very helpful, and they're certainly incumbent upon arbitrators, but increasingly the arbitral hearing centers will make sure that witnesses and other participants have the same sort of quality access. Many more questions to be answered, but perhaps that helps with an opening.
Ricardo, can I add just a little sprinkle? I have the poorest background here. That's what you just were addressing. That's the poorest facilitation of the, now, because I'm in a hotel right now. But what I was going to add is, Janet, your thought was, that popped up to my mind too. I always was quite reluctant to make a lot of use of the facilitation offers of the arbitration secretary. I was, let me do it myself. In this crisis, it was very helpful to come back to these things because they would help me to organize, solve technological problems, to get a good room. If you have to go in the, now it starts, but you couldn't go anywhere, they would help you to, get a hotel or something like that. So that's something I actually made a lot of use of in these times, to get help from the professionals that sit there, and they were quite eager to help, even because they wanted to see proceedings going on and not be postponed with no, major reason. So that was just practically very helpful for me.
Ricardo, may I make
please go ahead,
short comment, a very brief one?
Please go ahead.
You can see me, the camera is now working.
Yeah, perfectly.
I had the very, very first one, virtual hearing in the world. We were having a meeting, hearing in person in São Paulo, where we were about 88 people in a hotel room in early March. we had established very, very strict sanitary protocols and had instructed participants not to shake hands, no hugs at all, no kisses, everything was forbidden. During this hearing, the World Health Organization declared pandemic, and we had to suspend the hearing, and people went back to Europe, the US, and Asia, and we said, look, today is Thursday, we'll reconvene on Tuesday by Zoom. And we were all very skeptical about the success we could have in gathering 88 people in using Zoom for the first time in our lives. What I have to say is was extremely successful. We had a 5-day hearing. We had cross-examination. We had oral arguments, closing arguments, and everything went extremely well. What I'm telling this, because this was published by Brazilian press, was translated by an associate at the La Livre law firm in Switzerland, and published in Europe, in the US. That was the very first one. And I have had many after that. So I am enthusiastic about the hearings.
I have to agree with you, Jose Emilio. I have not heard a single person say, we had a hearing, a virtual hearing on Zoom. Not that I'm sort of a salesperson for Zoom, I'm not, but a virtual hearing with a reliable platform and say that they were disappointed. Now, there are many who are very nervous about it in advance, especially, if I might say, counsel, because they are quite anxious. They cannot be in the same room with the witness. How will they function? And they have all done very, very well. And they say, you know, the arbitrator will not be able to see the witness. But I'm sure you agree, Jose Emilio, that you can see the witness very clearly. You can see their reaction. You can see whether they are being advised or assisted. You can see them being nervous or uncertain about what they're doing when they're not sure that they are confident about their answers. You can see this all very clearly.
Janet, I personally prefer to have witnesses responding and being cross-examined on video rather than in person wearing a mask.
Ah, yes, of course, of course.
Well, that's definitely true.
I agree.
Normally black. Normally black.
Yeah,
Yes, exactly.
that's a good point. You know.
Hey, Doug, would you like to weigh in? Do you have any comment, Doug? You're on
You have
mute.
your mic off still?
Your mic's off.
You're on mute.
One of the interesting things for me, obviously internationally, the question of a different form of procedure for arbitration carries with it the potential for later challenge in relation to fairness and procedural appropriateness of the thing. And one of the things that has interested me is the way in which courts around the world have adjusted to the pandemic, because that gives a clue, I think, to the way in which those courts will regard challenges to arbitration proceedings that have followed virtual processes. And it's been fascinating to me to watch how courts around the world have sometimes with a little bit of trepidation and sometimes with real technological change proving difficult, adapted to doing justice virtually. So just from my personal experience and having been involved in a few webinars with parties from around the world, I can say that the Australian court system hardly missed a beat in terms of the hearings that were preceded virtually. And there is no backlog developed in Australia as a consequence of that, except in relation to criminal jury trials, which have proved a challenge. In Singapore, the courts have, except during periods of severe lockdown, proceeded virtually. In India, there has been an amazing pickup of virtual hearings. I was listening and talking to a judge of the High Court of Mumbai only a couple of weeks ago. He said he had 52 hearings in the week prior to the webinar, and he thought it was the best thing that had happened to Indian advocacy, because he would give them specific time slots within which to do their appearances. And of course, orality of submission is something sacred to an Indian advocate. And they have been forced to be concise and precise. The same thing, to a degree, has happened, I think, in England and in Ireland. Stefan would know more about Europe, of course, and that would be very interesting. And we'd be very interested in understanding what the situation is with the courts in Brazil. Are they likely, because of their own experiences, to support virtual processes for arbitration, including construction arbitration?
Well, in like just a brief one, in Germany and the surrounding countries, the state courts, they were only tiptoeing into virtual. That was, some of it was technically, they were not well equipped enough to really do that well. And then there was, you know, the judges in Germany, they are not really the technical freaks. They're not nerds on technical things, to be careful to say that. So that was a little, there was a slowdown in proceedings also in civil law. And, but I think they picked up quite well. I mean, they made a lot of effort to, you know, to put up the technology you need to do that. And I think we are returning to presence meetings, though. I mean, the courts go back into courtrooms as we have probably a little more loose regulations on distance and hygienic standards. We don't have a huge problem with the numbers of the COVID-19 infected. So things are loosening up a little bit. And I personally, in arbitration, do presence meetings again also with witnesses, but only with an amount of people that, you know, you can share a room with under the regulations you find. But I have a question for you, which popped up on my desk the other week. How far can we determine as an arbitrator? In this case, I was a sole adjudicator in the DAB. How much can I tell the parties and everybody else in the proceedings what I want to do, what I find out? If somebody says, no, I don't want to have this witness on a video, I want to have him in person for certain reasons, can I order him to do so? Is that because you don't find the regulations in most of the contracts I get engaged on? So that's a question I would like to ask you. How do you deal with that if somebody opposes?
Well, I think
your opinion seems to be a good way to go.
I think it's undesirable, from my personal perspective, to order parties to do things with which they're proving to be uncomfortable. So what I have done is engage more or less in a mediation process with counsel and a service provider for a virtual hearing, and to work through in a case management conference all of the practicalities that are of such concern to counsel. And indeed, I've got 3 of those CMCs next week in different matters where there are differences of view between counsel from various different cultures, where we will try to overcome, by quiet discussion, the issues that they represent. Now, sometimes, of course, there are strategic or tactical reasons why people object. But when they're forced in a Zoom meeting to actually explain their position quietly with solutions provided. I have found that by and large, one can find a process with which people are comfortable without having to dictate, without consultation, what will occur. So that's been my approach. Not so much with the courts, though, I think. In the courts, they're told what will happen, and they have to do it. But arbitrators, as we all know, have no power, like judges. So.
Yeah, that's.
I wish I could agree.
You just described that was came down to. We just had sort of a mediative process, and in the end we came to a solution. But it's just the question that came up to me: what are you going to do if somebody, for strategic reasons, just opposes because he wants to oppose on this thing? Then you have a problem. You can't go on. I mean, that was really on the edge there in that case. Yeah. So thanks. I have the same view, Doug, on these things. You just have to come to a conclusion.
Stephen, I noticed by Jose Emilio's movements there that he might have a comment too.
Good.
Yeah, very brief comment. I will answer Doug's question saying that one of the concerns we had in Brazil was the reaction of the courts if arbitrators would be holding virtual hearings, and if this would or would not be deemed grounds for setting aside the award at the very end of the process. I was, since the very beginning, very much convinced that this would not happen. Although I am no longer involved in litigation, the reality is I'm following you up from a distance, but the courts are working on a virtual basis. The court judges are working extensively on virtual basis. Then the question is, why the heck would they, in the end, decide to set aside for violation of any principles that you can claim under arbitration if they're doing the same?
Yeah, exactly.
Jose Emilio's point is exactly right. Once they have their own experience of the effectiveness of virtual arbitration or virtual hearings, they can see whether these complaints are actually legitimate or not. And you're right, Stefan. There will be some objections, some of which are actually well-grounded about witnesses who, for whatever reason, cannot be in a particular place at a particular time so as to have good access. I mean, those are always possible, just as they are in the pre-pandemic era, and we have to deal with those genuine cases as they come up. The strategic objections, everyone on this call has seen strategic objections to one procedure or another and must deal with them accordingly. But I do think that one thing that is unquestionably going to carry on into the new normal is that the procedural meetings that we've had leading up to hearings, and we are all seeing many more of them than we used to see in years gone by, will now, I think, almost inevitably be conducted by video conference. Mm-hmm. If someone says, let's have a CMC on this, or let's have a discussion on this, I think no one here would imagine today that that is by telephone. No. Of course, it will be by video. It will be more effective. It will be more efficient, and you will not hesitate to have it. So I think in some ways that's a clear benefit, especially in construction arbitrations, managing experts, dealing with the many different parties and issues that come up along the way. The hearing bundle, whatever the issues are as they come up, we will deal with them much more effectively in anticipation of the final hearing by video conference.
Yeah, the only aspect that I would like to raise is the following. Hearings, virtual hearings, may tend to take longer periods of time in light of time differences. It's very important. When you have US and Europe, US, Europe, and Asia, the time that you have useful time for holding the hearing is very short. Someone will have to work overnight. But how far you can go? How far you can go? This is one point. Time difference is of the essence. And secondly, I also think it's very, very important. The cadence of a virtual hearing changes. It's totally different from what happens in a meeting in person. You have to be much more objective. There is no room for rhetorical presentations. You have to go straight to the point, and you have to be very, very concerned on communicating your ideas to the tribunal and the opposing party. I think, and I have told many, many times, we have not yet discussed, and we have had zillions of webinars throughout the world, and one which is very, very important. We should hold, someone should sponsor it, as a webinar involving arbitrators, counsel, and specialists in communication, so that we can get their views and they can explain to us how we can efficiently communicate our views. I'm going too far. Thank you. Sorry.
I think that's a very good point indeed. And one of the things that are a challenge for those of us in construction are all of the physical things which are important to understand. In dispute boards, obviously, and in arbitration, seeing what it is that's being argued about is often quite important. And I'm not sure that there is a simple solution to that, although even before the pandemic, I was forming the view that long, dusty trips to sites or long helicopter flights over water to offshore oil and gas facilities could be better managed in terms of informing the tribunal about what it was that was happening. And so in a few cases, even before the pandemic, I've been involved in tribunals which asked for there to be video recordings, particularly with drones, of what it is that people are looking to explain. And that, I think, was successful in the cases I was involved with, but provide us with an opportunity for the future, again, to provide an alternative, perhaps, to actually physically visiting the places with which we need to familiarize ourselves. I don't know, Stefan, whether you have a view about this. You do a lot of on-site mediation and other work, I know.
Yeah, that is one thing. There's a little, from my perspective, I agree with the points, especially the communication aspect and the maybe to hear communication experts on how we do in these things. That's a very good idea. But for me, it's different. I totally agree with formal arbitration proceedings. The more you go into conciliation and mediation, the more you need the presence of the people you talk to. That's my experience. The more you come into a communication, which is very much between the lines, and you have to have a quick break of 5 minutes to see what's happening. You can organize that, but it's not the same story. So the more you get into a collaborative process, the more difficult it gets to do it virtually. That's my experience. But that might be just my social ambition, because I like to talk to people as they are and like to be around them. So for me, virtual discussions always are the second choice. But I totally agree. That was surprisingly efficient to have all these hearings virtually. Absolutely. but like we had a huge sort of a DAB, not really one. It's in between a mediation and a DAB process, which with a huge amount of money and a lot of public interested in that. Now, what we did is we said, well, that's perfect for doing it virtually, but we found out after 2 virtual meetings, we can't really get the point across because we have to discuss things on a very, very tiptoeing basis. So we decided to do the rest in presence, and we did it during these times, and we finished it within 6 months, which was a great success. What I'm saying is we will learn a lot to make it even better virtually. I think there's going to be a rest of proceedings I would prefer to have with people around, but that's just my personal view on these things. Some proceedings just don't make it well on virtual basis.
Stefan, I agree that especially with mediations, we want people to feel more at ease. Because then they will be open to new ideas, prepared to discuss things on a more relaxed way. But I think that is just a question of the extent to which we are at ease with the technology. I think
agree.
that will come. And you're absolutely right when you speak about just wanting to have a quick sidebar or having someone step out of the room. It's much more sort of fluid when you are in person. But I think that those facilities, that kind of ability will come with time as we become more used to it. The cost benefits are huge with this way of proceeding. In the courts, for example, the judges are saying, well, thank goodness, I can run through any number of procedural issues, pre-hearing procedural issues in a day, far more than I ever could. Counsel are not sitting in the back of the courtroom waiting for hours for their turn to have their 15-minute discussion. For us, in large matters, the idea of flying, dozens of parties, witnesses, experts, counsel, to be put up in a hotel room in a distant place for weeks on end, all of that I think will change. So again, without wanting to be sort of too futuristic about it, yes, there will be some things that we will prefer and hold dear in terms of in-person meetings, but over time, I think our thinking will change on that.
Stefan, you must have been involved over the last few months in trying to find solutions to some of the issues in the German construction industry from a practical and legal perspective. I'd be very interested in hearing what your experience in that respect has been, because I was interested yesterday in the discussion about the level of flexibility compared, say, to English law, which appears to be available in Brazilian law. And also the distinction drawn between French law and English law, so far as dealing with unforeseen events are concerned. Your experience in that context would be of interest, I think, certainly to me.
Well, I'll be happy to answer that. Well, Germany was and is quite unique because we were really lucky in the construction business. The construction business in Germany sort of sailed underneath the radar of COVID-19. Nothing severe happened. All the construction projects I know of, they went on. They were slowed down a little bit. It didn't always go too smoothly anymore, but none of them were stopped and no severe damages. So that was a message. When we started the lockdown, I thought this is it for the construction branch, because they have very small margins, and I thought this is going to break them, but it did, because, and that's for my job, that was something I also could not imagine before. Everybody was willing to cooperate and solve the problems that were brought into these construction projects by COVID-19. It was not, and I would not have expected that, actually. I mean, I've been in the business for 25 years. That was a very positive surprise. Both parties, at the very beginning of the lockdown, kind of sat down and said, so what are we going to do? My Romanian steel workers won't come. How do we get some others? You know, do I have to go to somewhere around the world, or can we have enough? So the contractors and the employers at a very early stage sat together and tried to find solutions to keep things going. And so there is hardly any disputes arising from the situation so far. There are some on the horizon I can see coming, because when you collect up, you know, when you see what happened, you find out, oh, that cost me a lot of money, and then you want the other party to pay some of it. I might come to that later, but in general, that was such a positive experience to see that the people in construction business, which before were really in sort of a war against each other in Germany, I mean, they kind of just cuddled up a little bit and said, how are we going to solve the problems?
But what about the public sector, Stefan? What about the public sector? My impression of Brazil is that there is very serious concern in the public sector about accountability arising out of Lava Jato and other issues.
Yeah, well, that was...
And insofar as you have seen in Germany the need for the public sector in an accountable way to deal with issues and reach compromises, how does that work?
That was very surprising too. The public sector, public entities, and even the federal institutions that had to, you know, are dealing with building things, they were very proactive from the beginning. We had very early, we had some papers that came out from the ministry in charge of construction and procurement of construction works, and they sent out a paper how they considered COVID-19 related problems should be solved. And that was, to my opinion, I mean, some of the legal aspects were maybe, if you look at them closely, not perfectly addressed. I mean, you could think of it, but in general, that was very well balanced, because they said, hey, come on, we're going to split the problems. If you have, you know, additional costs for hygienic things, if you have additional costs or need some time because things are slowed down, because we can talk about that. And they lifted up the blanket, and so all the public-driven construction projects, they had the space to come to collaborative solutions, because the government in the early stage said, you're allowed to do so. You know, they said very early, this is force majeure. Don't worry about it.
And you know, Stefan,
that was in early March. That paper came out.
Stefan, could I interrupt you here, please? I'm sorry for that.
I'm sorry, I'm talking too long.
No, but it's excellent. You know, we completely escaped from our plan here. I really wish construction be like that. We don't really need to plan anything, because that's how we do it here in Brazil. We don't need to plan anything. Construction just goes on, and then we have arbitrations, and that's what keeps our salary, right? But what I'm like to, if I could weigh in and actually direct a question, taking the hook from you and direct it to José Emilio, you know, and the point that Doug was bringing here, considering Lava Jato and everything that's happening here in Brazil and accountability. And how, José Emilio, how would you see the possibility of getting public agents to be cooperative, to collaborate really, in terms of perhaps even reaching agreements, not only substantially agreements, but also even procedural agreements to make procedures move better? And of course, please give us your opinion if you think public agents are entitled to work cooperatively.
Yeah, look, Lava Jato car wash is something which is part of our day-to-day in Brazil, unfortunately, but it's true. And we have the cases going on and the impact on the big entities that were affected by the car wash and the wrongdoings, such as the case of Petrobras, which is the leading example known throughout the world. This is something that has to be dealt with on a case-by-case basis, but it's important since I have had the opportunity to read as a publicly traded corporation. Petrobras has published announcements in pursuance of the Brazilian SEC rules saying that they reached agreements and settlement agreements in ongoing arbitrations. So I would not say that it is impossible. Of course it is. It requires lots of negotiation, more than normal negotiation, and the approval by a board of directors, checking with the authorities that are in charge of corporate governance, and also external controlling agencies of the federal government, but it is possible. What I think it is important, and I would not be willing here to send a message that our day-to-day is in construction is dictated by car wash, as that in this country we have the vast majority, and you know this, Ricardo, you were involved, of the projects relate to public-private partnerships, the PPPs, as well as concessions that are preceded by construction, expansion of toll roads, for instance. Let's take the example of toll roads. They were dramatically affected during the social distancing period. We had not a lockdown, but we had a very drastic social distancing period. And the cash flow was really affected in the toll roads. I think, will they renegotiate? Of course they will. Of course they will. With those concession agreements, those PPPs, for several reasons. One of them, they are very long-term contracts, 30, 35 years. Secondly, what they can always do is to have a different time planning for expansion, for additional works. They can postpone dates, but more than that, I would say that virtually all those projects are on a project finance basis or a structured financing basis, which puts the pressure on the parties by the lenders and financiers. Of course, they do not want to go into stepping rights. They do have stepping rights, but they do not want to exercise the stepping rights. So I am optimistic, and I think, and I would say what Aisha said, I will borrow her words at the end of the section today. Yes, it is collaboration, renegotiation. This is not a construction problem. This is the humanity which is affected. So I think I am absolutely realistic about car wash, but I think we have other areas where we have good opportunities to move on in renegotiation imposed by lenders.
Okay, thank you, Zemilio. And look, we were talking here, one thing that we talked before the panel with Stefan, and I don't know how it goes in Toronto, Sydney. I completely understand, and I think we do have a space for this kind of collaboration, and even, you know, we can put efforts into reaching agreements with public authorities. But since Lava Jato, what we've been seeing is the public agents have been afraid, the good ones, right? the good ones, have been afraid of signing documents because investigating authorities are just overwhelming. They are, you know, now after that is just something that's everywhere, and sometimes, and this often happens, for no actual reason or very solid reasons, the public agents are penalized. So how would you deal with this, right? I would like to know how it's going on around the world. And of course, if Zé Emílio could also weigh in with his visions in Brazil, perspective in Brazil, you know, I'd be thankful.
It seems pretty clear that public accountability has been a challenge around the world because everything has been thrown into crisis. It's called for very quick action on the part of public authorities, action at a pace and based on a level of uncertainty around them that is unprecedented and that disrupts their normal patterns or the patterns they are developing of accountability and transparency. So we have had a number of challenges, which probably have not been heard of around the world, but a number of challenges ourselves to our own public authorities and the way in which they have let contracts and the way in which they have dealt with subsidies and other forms of assistance. I think that that's bound to occur around the world. And again, that is not that's special to our current experience, but it's not special necessarily to any one economy or any one system. And we're all having to find ways to deal with that, to restore and establish new forms of transparency, new forms of accountability that will not prevent public authorities from acting in a timely way to address these challenges.
Well,
Please, Stefan.
Just to add that, I sometimes get hired solemnly for one reason. They want a neutral, they don't have to explain who he is, to write down what the result of the negotiations were to present it to the public authorities that you know, are meant to control them. So I have a lot of public forced projects. I'm there as a neutral just to, you know, bring the relief of being able to justify what we're doing there to find a collaborative solution, because by themselves they would probably not be allowed, or they would have a problem to explain it. So they just hire me to say, well, he said we can do it. Look at it, it's all okay. So I think that's, as you said, is a problem you have all around the world, and it's a cultural thing. It's not a construction thing, it's not an arbitration thing, it's a cultural thing. It's how we deal with responsibility.
I think Stefan's absolutely right. The fear by public authorities of subsequent criticism for being bold in reaching a settlement of something is something that gums up the works. And you can see it very clearly at the moment in India, for instance, where almost every construction arbitration involving a state-owned entity is guaranteed to run not just to an award, but then to a challenge through the courts of the award, which is usually unsuccessful, but which enables the public authorities to say, we didn't decide it, someone else decided it. Now, in India at the moment, there is a strong pressure from the central government to try and find ways to overcome that problem, because it is a very substantial inefficiency within the public sector system, particularly in relation to construction. And the way to solve the problem is firstly to impose an expectation by government that public servants are expected to solve problems. And secondly, to have an accountability process which ensures that they are protected from later criticism and attack. If you take, for example, the huge efforts that were made before Hong Kong was handed back to China by Britain to overcome issues of corruption. You saw the establishment there of ICAC, Independent Commission Against Corruption, which had and still has enormous powers of arrest without trial, incarceration without bail, and a range of things. And the fear that effective organisation put into the hearts of public servants led to an inability in Hong Kong for many years to actually negotiate any construction settlements in construction disputes. But there developed a process of quite complex mediation where, a little bit like Stefan describes, the dispute was submitted for initial mediated determination by someone very senior, retired judge such as Stefan is, who would give a non-binding opinion. And then there would be negotiated from that a settlement. And that is something that I've certainly used in my time as counsel, now past, in Australia with big public sector projects where I call it finding someone to sprinkle holy water on the deal, on the basis that at the end of the process, it's almost certain that there will be some political crisis or other sought to be created around a big transaction. And in addition to that, what has happened in Australia, interestingly, to motivate public servants, is that the auditor of government, which is an independent auditing role adopted by a separate government organisation independent of government to look at propriety, has added to its responsibility judging whether, not just whether something was done properly, but whether something was done efficiently. And that has introduced the motivation, against fear of criticism that it was inefficient, to actually solve problems rather than let them be determined by someone else.
You know, Doug, before I give the word to Zé Emílio, let me get an idea that you brought here, and also, you know, take advantage here of a question that came from the audience. This is a friend of ours here, one of the most relevant lawyers in Brazil, Júlio Bueno. He's here and asking us if here, this goes to all panelists, of course. How do you envisage the proposal for an industry concerted action towards compliance? Should construction industry foster the creation of voluntary guidelines to prevent corruption? José Emílio, if you can perhaps you know, match a little bit of Doug's words to this question, can you give us some thoughts?
Let's do the following. Let's first, Doug, answer Julius' question, and then I'll
Sure.
jump.
Feel free to do it.
Oh, you're asking me?
Yeah,
Well,
I'm suggesting.
I think certainly there needs to be a transparent process within any national construction industry, which demonstrates processes that seek to eliminate corruption. And industries will, national construction industries will benefit from that. So it's in their own interest to do it and to be seen to comply with it. However, my experience internationally and locally is that the amounts of money involved and the risks involved in construction tend to encourage solutions which are, shall I say, shortcuts, which ultimately lead to criticism, sometimes criticism of corruption. And therefore, a wholly self-organized process within the construction industry is likely to be less credible than one to which the construction industry contributes, but which has sufficient levels of independence to try and demonstrate that it keeps the players honest.
Great.
Yeah, let's go step by step. I think we have to be very clear. We had in Brazil, by far, the worst case of corruption in the planet. This is something that we certainly would not like to have as the world record, and we do. Unfortunately, this is there. There is no way to come backwards. But what I think is that once you have this situation, we have this traumatic, the trauma, we immediately move to the opposite extreme. And then you have a sort of control that comes from different sources, especially the public attorney office, which takes every single movement that you normally have. And Doug mentioned shortcuts. Shortcuts may be very valid and legal. A shortcut is not something that will imply corruption, may lead to the excessive number of shortcuts. But sometimes we know, we are involved on that. We know what happens in a construction site, and you have to make decisions, conforming decisions, and so on and whatnot. But it's not everything is criminal, is corruption, and then we move from one extreme to the other. We have to come back step by step to a middle point where we don't have corruption, but we can have some flexibility. Otherwise, we will not be able to construct anything in the world. Of course, we all know that we have the contract with lovely words, pages and pages, and we have the reality of the work, which is the life side of the contract. It's the life of this contract. So I think, I agree, Julio, that we would have to make an effort to have what you were proposing and Doug is saying. But I think it take a while. And of course, the industry, we know, taking the example of the car wash history, was very effective in creating certain agreements among its members to avoid competition, for instance. Okay, I don't want to use the technical word here, but you understand what I mean by that. Blocking the access. So if the industry was able to do that, could be able to establish good rules to avoid corruption, this is something. But another point that I would like to make is what Stefan said. It is, we have in Latin America, but especially in Brazil, a cultural gap. It's not a construction problem. Why do we have construction arbitration cases with claims exceeding 150? Why? Ranging from $1 to $100 million. Why do we have that?
Do we always have to get things to be solved jurisdictionally, right?
Yeah.
Do we need that?
And of course, you could have had different solutions. Mediation, for instance, could work extremely well. DRBs. Why DRBs are not that successful in Brazil? In Latin America, generally. Why? Because it's a cultural gap. We don't have the sense. And in the cases where we have mandatory DRBs, which are contracts which are financed by multilateral agencies, what happens? You have the final decision of the DRB, and the next day you have an arbitration filed. That's cultural.
Oh, I just wanted to say, Jose Emilio, you speak absolutely correctly when you say somewhere between paralysis and corruption, we must find a way forward. And now that we have just begun to catch our breath and come to grips with this pandemic, we must brace ourselves for the next huge challenge, which will be the economic turbulence that has resulted from all of the disruption that we have faced. And it is a cultural shift ultimately. I think, Julio, and bless you for coming on the chat to ask the question. It may not be that it is appropriate or feasible for industry itself to produce these guidelines, to produce this kind of mechanism of self-accountability, but it is very much a cultural change. And I am very much optimistic that having found ways to navigate the pandemic, we will then find ways to develop this cultural change of being nimble, of being able to face these challenges, but still expecting to do so with integrity, to do so in a way that would be accountable. Why? Because increasingly the public will expect it. They will demand nothing less, and the reputations, corporate reputations and individual reputations will depend upon it.
Please go on, Stefan.
Stefan, you're on mute.
You're on mute.
Much. See, I was so much caught up with hearing you say such truthful things. Jose Emilio, that's one thing. Let me talk to you as a German. We consider ourselves very much on top of things according to corruption, which is, if you look closely, not always true. But just let's say it that way. And I'm very much support the idea of compliance. But what you said is so true. We just overdo it. You know why we don't have any German big construction firms anymore? Because they can't compete internationally, because the compliance rules are so strict that if you get caught with anything that's usual in the market, you're taken out. And so we don't have any big construction companies in Europe anymore because the African market is dead for us. Nobody from Germany goes there anymore because ask Siemens about it. I mean, they paid billions of euros on fees they had, because they, didn't comply with the rules. So that's we have to find a margin that leaves enough air to breathe and to find a good solution. And if an employer wants to pick this contractor, then he should be free to do so. But in Germany, you're not. We have European procurement rules for public procurement. They're so strict, you can't pick the one you want. So what I'm saying is, and COVID-19, it's just like it brought up the best and the worst, not only in us, but also in society. And now we see it clear on the table what it leads to. If, like in our case, the public authorities said, well, if we have the COVID-19, let's react real quick and do it in a way so everybody can deal with it in a proper, most efficient way. Things went well. So why don't we do it not only in this pandemic scenery, but do it in general that way? You know, leave people space to breathe.
No,
arbitration and conciliation, all these, we are a good tool to facilitate that idea. Because we are, at least we should be neutrals, and we can always help to do that. The closer we are with the project. If you do standby DRBs and stuff like that, you know what I'm talking about. You're part of the project, but you're a neutral. If you stay neutral, you can help a lot to facilitate that idea of efficiency.
Yeah, Ricardo, I would like to add something to what
please go on.
Just said. And I think that unfortunately, you are right. You are absolutely right. When you say, how can a construction company in our countries go worldwide once we have strict compliance rules and what happens in certain markets? You mentioned the German companies and Africa is dead and so on and whatnot. I ask you a question, what can we get out of our construction companies, taking in account what happened and with presidents and prime ministers throughout the world?
Mm-hmm.
Who will trust? Who will trust? See the problems. I do not want to mention any country here because there are many, but the press is there. Recently, just days, the day before yesterday, some cases, new cases were published by the press in Latin American countries. It is very sad. And something that you mentioned that COVID-19 brought, in my opinion, and I saw as soon as pandemic was declared, and something that I saw and said, okay, unfortunately, we are not in the right track yet. Because I did get some consultation from companies saying, look, there is a force majeure case here. And it's also hardship. And then you say, give me the facts. I need the facts.
Mm-hmm.
The force majeure clause is not triggered automatically. I need to know the facts. And why do you say it is hardship? And in the end, you get to the conclusion that we had in those cases lots of opportunism.
Mm-hmm.
It was an opportunity to claim force majeure hardship to get benefits out, and said, I had these problems before. I'll take this opportunity to start saying, look, I was affected by a pandemic, by COVID-19. And what I want to say, of course, I told them, look, if you want to go to arbitration, it's your problem. Okay, I do not see any grounds for your getting a favorable award. Because in the end, what happened, and this, Stefan, you understand extremely well, because our position is very similar to what you have in your civil code, the BGB.
Mm-hmm.
What we had here is a sort of a major disturbance in the performance of the contract that may create a temporary impediment or impossibility for performance. But this does not lead to the termination of the contract.
No.
Leads to renegotiation.
Yes.
But renegotiation has come spontaneously. I don't trust, although we have here in Brazil one of the most reputable professors in civil law, Professor Anderson Schreiber, who has a position. I'm not in agreement with him, but I fully respect. It's a very, very well structured, because he says that there is a legal duty for renegotiation deriving from the good faith clause in the civil code. And the good faith, and the good faith clause here, Stefan, is, and to you all, is the same language of the 422, Article 422 in the BGB. It's a Treuend Glauben in the end. I certainly do not agree. I don't see any legal duty to renegotiate. It is desirable. It is, but something that has to come voluntarily.
Ricardo, can we have another 2.5 hours to discuss this, because he apparently knows the meeting really well. I mean, there is a provision.
You know,
actually,
there's a question. There's a question.
An hour and a half about this.
Stefan, we have like 5 minutes. How about that? But
Okay.
you know, we have a question here that comes from Leonardo. Since he's my president, I need to ask you guys.
Yeah.
Could we discuss about a little bit on the paradox of duty to renegotiate versus opportunism?
Well, sure. Just a brief insight on that. We have a provision in the statutory law. It's not only Treuend Glauben, the good faith, it's precisely the provision 313 in the German Civil Code.
Yeah.
And that exactly states that what Jose Emilio just pointed out. But on a legal basis, if you make me as a judge apply that clause, I would have to check if there's a root cause between the pandemic as something that was not foreseeable when you signed the contract and the results you're claiming for EOTs or even for additional money. And I have to relate that root cause to the position you're in. How can you do within, reasonable economic efforts? How can you provide that risk that has been allocated under the contract to you? How can you deal with it? I have certain measurements to deal with that. And the unique situation is we never had after World War II with that provision. The unique situation is we have a situation where we have a global breakdown of supply chains. And that is a risk that comes from the outside. It's not within the contract. It comes from absolutely from the outside. And what we deal with right now is that is the idea is you can, if you have an obligation to renegotiate, to re-establish the contract, it's not about allocating risks. It's about dividing risk. Like you both take some of that risk because it hits you both, and that's what we call what you were just pointing out, Jose Emilio. You have to, under these provisions, you have to renegotiate. If you can't claim you have a root cause between COVID-19 and what happens to you, then you don't get anything. You don't get EOT and you don't get money. But if there's some, it doesn't move over totally. It's split. So that's the idea under the German civil law, which is very complicated to admit, and it's not justified yet by the Supreme Court. There's no judgment yet that says it's that way.
Janet and Doug, any thoughts?
Stefan, I think you are absolutely right that the devil is in the detail. And every case needs to be taken on its own facts. So even when I hear you say, well, there has been a global breakdown in the supply chain, I say, well, maybe, but you have to speak in specifics about, which commodity, which manufactured goods, where were they going to? Because we do see quite differently. You only have to go online to Amazon or one of the other major sellers, and maybe you cannot find that kind of good for a long time, but maybe it will come back. When has it come back? Or if it's not there, maybe there's an alternate supplier. So we do need to look very carefully, and I don't think it's possible even still to make blanket statements about any of these issues.
No, but isn't it a nice opportunity to have a chance to, for once, not allocate risks, but to deal with them in a proper way? I mean, just if you have if you can deal on this special case, I thought there was a good opportunity coming back to the initial thought. Well, things went smooth because they collaborated on it.
Professor
Joy
Jones?
of being a civil lawyer. Just before our time runs out, there's one thing I'd like to say to my Brazilian friends, and that is this. Lava Jato, about which I know a reasonable amount, is not something of which Brazil is the sole sufferer. In Australia, there have been regular public inquiries, we call them royal commissions, into the construction industry, in which, when they slammed the till, they caught the industry's armpits, including collusive tendering and a whole range of conduct very similar to what we see in the Brazilian context. You are not alone in your construction industry with this issue. It is an industry issue worldwide, and which arises from what I said earlier. There are temptations to solve difficult problems in the industry throughout the world. If you take Canada, the Montreal construction industry was the subject of a royal commission which exposed the most egregious corruption, direct corruption, collusive tendering, and bad practices. It is not something of which Brazil should be regarded as the sole source of this problem. And your Brazilian construction companies should go proudly into the world saying they have solved the problems which every other construction industry in the world will suffer, but for the grace of God, go I. And you should not regard your problems as unique.
Mm-hmm. Just to second the notion, did you hear about the German car industry? I mean, that was the biggest case of corruption you could think of. They lied to the whole world about the impact of...
No, you guys, wait a second. You're not allowed to take that out from us, really. You got to be known for something. You know what? You know,
it's a great television show, I must say.
What you will be known for is the way you have dealt with it, the way you have faced up to it, the way you have confronted it.
Yeah.
Thank you. You're so kind. You're so kind. It's Emilio. What do you have to say about their kindness?
I agree with Janet when what she said now, because normally my friend said, don't you find difficult to go to international arena, to your hearings throughout the world, and have to face your colleagues talking about the corruption, the car wash, and so on and whatnot? Absolutely not. Absolutely not. What I can tell them, look, we at least holding this record, Guinness record, and Ricardo is absolutely right. We don't want you to take it from us. We took the measures. We took the appropriate measures. We made public this scandal of corruption. And I say, look, unfortunately, it happened, but measures have been taken. That's my view. I fully agree with you, Janet. That's the way it works.
Thank you. Thank you very much. But guys, we are running out of time. What fantastic. Could you please, each one of you, make a final and quick remark? It's perhaps starting from Janet.
Well, only to say thank you very, very much for taking on this leadership and holding the conference, notwithstanding the challenges we have all faced. As Aisha said in the last panel, this is a time very much for us all to come together and work through the challenges that we collectively face. And conferences like this, I think, are extremely important for doing that, for exchanging ideas and experience, and for exchanging thoughts on solutions that we might develop.
you so very much, Janet. Doug?
Well, it's just been a privilege to be part of this conference. It measures up, as usual, to the high standard of Brazilian conferences with which I'm familiar. And it's a privilege to be part of it.
Thank you. How about you, Stefan?
Well, thanks a lot that I could be part of it and could learn a lot. And I apologize for me getting carried away with things that might seem a little peculiar once in a while, but that's just the way it is. Thank you very much for letting me be part of it. It was a pleasure. Thank you.
Thank you, Stefan. And you, José Emilio?
Thank you very much for this invitation. Enormous pleasure to join you this morning. And I hope we can have more collaboration and renegotiation between the parties. And we are arbitrators. We sit as arbitrators, but we want to arbitrate good cases and cases where people, they are complex, but those that they could have resolved otherwise are not that challenging. So let's focus on the real cases, the very cases, and avoid spending time and wasting time when you can collaborate and renegotiate. Thank you.
Fantastic, José Emilio. Thank you very much. You know what? I couldn't agree more. Amen to that. You know, Doug, I just hope that the next shortcuts we make, and if it's possible, then if we spring some holy water that then don't boil, right? So guys, thank you all so very much for such a formidable time. I'm sure that all attendees, just like myself, are living today with great ideas to ponder upon and implement in our daily tasks. Yeah, especially while dealing with construction disputes in this scenario of global sanitary crisis. And I wish you all the very best, and be sure that I'm counting on the days to give you all a big Brazilian hug, all right? And now, to close the panel, I'll give the word to our president, Leonardo Toledo. Thank you.
Thanks a lot, everyone. It's so great to see that this panel works people are so experienced that has so many things to share, and it goes like easily and dynamically. I told Ricardo here, man, we just could leave these guys in a room and just listen, because they do the rest. Thanks a lot, man. You guys are awesome. I would like to invite to join me in this closing remarks of the conference. It's been 2 days of conference, and it was such a pleasure. I would like to invite also Wolfgang Breyer to go with me in this final remarks on this conference. I have to make some small notices here. First of all, we've been trying to have a crystal ball here these 2 days to see what's going to happen. A couple of months ago, or at least 4 months ago, everything was cloudy. Now we can see some light in the end of the tunnel, and hopefully some ideas we will help to improve with this discussion that we have here. One it's quite clear, which is collaboration. There are some limits to what contracts can do, but a big part of what we have to do is related to collaboration. So I would like to thank our ICLA very much and give the word a little to Wolfgang. After that, I'll have to, Wolfgang, after your speech, I will still have to thank our sponsors. So please, I would like to thank ICLA very much for being cooperative with us and sharing your guys' knowledge on subjects that Brazil has to improve, and also to collaborate with ICLA endeavors. Please tell our attendees these videos probably will be shared in social media. Tell us about ICLA, what you guys have been doing. Why should everybody join ICLA, Wolfgang?
Right, Leonardo, thank you very much. Indeed, the pleasure was all ours. Just briefly to introduce ICLA. ICLA stands for the International Construction Association. We are, I dare say, unique because the intention and the purpose behind ICLA is to compare and contrast different law systems, different law families with focus naturally on construction law issues globally. You might say, why should I care about any kind of law, local law? Because I do have a contract. This is an issue which is often underestimated or even overlooked, meaning the impact of the applicable law, which is not necessarily the law where the site is located. It might be both. And I'm not only talking about mandatory rules and regulations, but also others. And so therefore, I mean, it is not only good to know, it is necessary. There is a need to know how the respective works. And I'm also talking about the law chosen by the parties, which is often a kind of, I heard it last week, a neutral law. And as neutral, it was introduced to me the law of Switzerland, which is great. But people choosing these kind of laws of a third state or country are probably also sometimes not familiar in detail with what they did. And as I said, the impact of the respective law on the contract might be considerable. So therefore, and this was the idea, in order to figure out what is the respective law, what is relevant to the contract, how does, for instance, taking over work, how does taking over work in China, for instance, there is a gap we identified in terms of literature available. You might find in Russia, Russian literature. You might find in China, Chinese literature on that issue, but you highly likely will not find English written papers or whatever on these issues. And this was the idea to set up this association, which is, by the way, open for every kind of construction professional globally. And that was the reason that we set up a database, which is, I dare say, in the meantime, well structured. So our members can find, by using the database in a reasonable way, hopefully sufficient information on the respective issue at hand. We do have and I'm very proud of that, we do have a very strong academic background. ICLA collaborates, cooperates with leading universities globally in terms of construction law. For King's College London, we do have the University of Melbourne, we have Peking Law School, we have the University of Moscow, we have British University of Dubai, just to name a few. So this is what enables the ICLA to discuss, to compare and contrast all these issues on the highest level possible. I'm very proud of that, and I want to use the opportunity again to thank our members. We had a lot of speakers from ICLA, or actually, which are members of the ICLA, not just to mention the last panel, where we had at least 2 members of the ICLA, meaning Janet and Stefan, and Doug, maybe a prospective member of ICLA too, hopefully. So I want to encourage all of you who are still listening to become a member of the ICLA, because the more qualified members we have, the better the whole thing gets. So thank you very much on behalf of the ICLA, to IBDiC, to Leonardo, and all you guys who organized this event in an astonishing way. Thank you very much indeed.
Wolfgang, we thank you. We thank ICLA. I witnessed events of ICLA. I became a member of ICLA, and I am a professor advisor of some academic works on construction law, and I've been advising them that get access to this kind of networking, and I can witness also this background, this academic background that you mentioned. It's something that clears, shines when we talk to people around ICLA. They are very welcoming. I've been to Japan with you guys last year, and this idea of academic background, of making a connection between market and academia, is something that is it's shiny on the ICLA organization. So thanks a lot, and I think we very much appreciate it. I have to mention to our community that what we discussed a couple of days ago, Wolfgang, that we are intending to have another joint event of IBDiC and ICLA for 2022. At first, the idea was to have this year a physical event, as everybody know. And in a second view, we were thinking of doing that in 2021, but 2021 seemed a little bit still uncertain. So after we discussed a little bit a couple of days ago, we understood that the best thing to do would be a joint conference, possibly a physical one that everybody can be together and enjoy the presence and the exchange of energy that, of course, the virtual event cannot replace, but it is what it is. We adapted to the reality. And so 2022, we are very much looking forward to it, so that we can do a joint, another very, very high level event. We take very serious. It's important for you guys at ICLA to know. We are very serious, we are very committed, and we have to always do our best. All that said, I have to thank again our sponsors. Guys, you help putting this show together. Barros Pimentel Advogados, Hormigão Act, Jamundo Neto Advogados, Toledo Marchetti Advogados, and Matos Filho Advogados. As our supporters, we had AACE, CIARB, CEBAR, IBRADIM, Curso Prático de Arbitragem, and Infra Women. Guys, thanks a lot one more time for that. Our speakers for taking the time. We know that with all this the difference of time, some people in China, some people in Australia, you guys have been so great and accessible to our moderators to discuss the panels. Of course, to our participants. And please be aware that this content will be probably edited to be more appraisable for the viewer, but it will be somehow available in our networking channels. And to say that with a sense of duty being fulfilled, I would like to conclude, and I'll leave one more time the video of Casa José Couto for everyone to be inspired by the work that these people have been doing, and say that aside of construction law, we have to make a difference in our community. Thanks a lot everyone. We see you in next events. And Giovanna, please go on with the video. Thanks, Wolfgang.
Likewise. Thank you very much. Stay safe.
You too. Thanks, everyone.